Hello. I think by clicking on this video you're eager to learn more about international law. That's good. Really good. You found IntlLaw on time, my friend. Exactly on time. We've just shared a journey through the fascinating road of international law, and we're waiting for you. Before everything, I wanted to send my regards to Professor Banu and thank her for her well-presented lectures that enlightened our way. If you want to catch up more with the journey's path, you can find her precious videos in the playlist mentioned above, my friend. From today, the Academy has asked me to be the leader of the journey, and I must confess, what an honor. Well, I don't usually talk about myself that much, and all I want to say is that my name is Walter, just a simple professor in love with international law. I'm going to prepare some lectures for you about the sources of international law, and I really hope you're going to like them. As we begin, it is essential to understand why the sources of international law matter so deeply. Treaties, customary practices, and general principles are not abstract ideas. They form the framework that guides the conduct of states and informs the decisions of international courts. By studying these sources, you equip yourself with the knowledge to navigate the legal landscape with clarity and confidence. This understanding is invaluable, whether you are negotiating agreements, analyzing disputes, or contributing to research in international law. Over the coming lectures, we will examine each source carefully, exploring not only their definitions, but also their application and significance. My aim is to provide a structured and methodical approach so that every concept becomes clear, every principle understandable, and every connection between the sources apparent. In doing so, I hope to assist you in building a solid foundation that will strengthen your work, your study, and your contributions to this discipline. So let us proceed together with focus, precision, and purpose. These lectures are designed to guide you step by step, to illuminate the pillars of international law, and to give you the tools necessary to engage with this field meaningfully. I am glad to have you here, and I look forward to our exploration of the sources that shape the law between nations. Before we dive into the subject of our lecture, it is important to consider the different kinds of sources themselves. Some sources serve as the intellectual or conceptual pillars of international law: history, trade, sociology, and the philosophy of international law. These pillars provide context and justification for why certain rules emerge, shaping our understanding of what law between nations should be. Alongside these pillars are the formal or legal sources: treaties, customary law, and general principles. These are the instruments through which the intellectual foundations are expressed and applied. Together, these two types of sources create a comprehensive framework for understanding and practicing international law. To begin our study of the sources of international law, we must turn to the foundation established by Article 38 of the Statute of the International Court of Justice. This provision is often regarded as the definitive statement of the principal sources of international law. It identifies treaties, customary international law, and general principles of law recognized by civilized nations as the primary sources. Additionally, it acknowledges judicial decisions and scholarly writings as subsidiary means to determine the law. Article 38 provides both a practical and theoretical framework, guiding courts, states, and scholars in understanding the origins and application of international law. It is important to recognize, however, that the concept of sources of international law did not begin with the statute of the ICJ. For centuries, jurists and diplomats debated, recorded, and applied legal rules between states. In the medieval period, legal scholars and canonists laid the early groundwork. Treaties between kingdoms and principalities were recorded, and customary rules were observed across Europe. Figures such as Francisco de Vitoria reflected on natural law and the duties of rulers toward one another, offering early conceptual frameworks that foreshadowed modern codification. While these writings were not formally binding in the contemporary sense, they established enduring principles, showing that legally recognized sources existed long before codification. During the 17th century, Hugo Grotius emphasized that treaties and customary law were binding upon states. He argued that repeated state practice, accompanied by a sense of legal obligation, what we now call opinio juris, created enforceable norms. Grotius also recognized general principles derived from natural law, bridging philosophical reasoning with practical international conduct. His work systematically identified the sources of law between nations, influencing generations of jurists. The 18th and 19th centuries saw scholars such as Samuel von Pufendorf, Emma de Vattel, and Henry Wheaton build upon these ideas. Their analyses classified treaties, customs, and general principles, providing a structured understanding for states and legal practitioners. At the same time, treaties addressing commerce, diplomacy, and boundaries proliferated, particularly as European states expanded overseas, contributing to the practical recognition of rules later codified formally. Several landmark conventions illustrate the growing recognition of sources. The Hague Conventions of 1899 and 1907 codified rules of war, neutrality, and diplomacy, formalizing customary practices and establishing precedents. Similarly, the Paris peace treaties after World War I incorporated both treaty and customary elements. In addition to treaties and conventions, soft law instruments emerged. Declarations, resolutions, and recommendations adopted by international organizations influenced state behavior even without formal binding force. The 1920 Covenant of the League of Nations, for example, set expectations for state conduct and dispute resolution. These documents contributed to the conceptual framework later recognized in the ICJ Statute. Leading up to the 20th century, doctrinal writings intensified, producing systematic classifications of sources. Legal textbooks, commentaries, and scholarly articles reflected a growing consensus that treaties, customs, and general principles were fundamental. While no single binding document existed, the combination of state practice, judicial decisions, and academic work provided a coherent understanding, foreshadowing the formal codification in Article 38 of the ICJ Statute. Questions often arise about whether there is an order or hierarchy among these sources. Historically, some early conventions, such as the 1907 Hague Convention on the Laws and Customs of War on Land, Article 7, addressed the sources of law and suggested an order of priority in interpreting rules of war. However, modern codification, especially Article 38 of the ICJ Statute, does not establish a hierarchy. Treaties, customary law, and general principles are treated as equally important. The statute recognizes their authority without ranking them, leaving courts and practitioners to interpret them in context. So remember that. After 1945, codification continued through multilateral treaties, such as the Vienna Convention on the Law of Treaties, 1969, which formalized rules for treaty creation, interpretation, and termination. Human rights treaties, environmental agreements, and regional conventions drew upon the framework established in Article 38. This evolution illustrates that codification is not a static event, but an ongoing process, responding to emerging issues while grounding them in recognized sources. It is also worth noting landmark cases that reflect the historical development of sources. Early ICJ cases, such as the Corfu Channel case and the asylum case, demonstrate the court's reliance on both treaties and customary law, confirming the codified source's practical relevance. These cases show that knowledge of the history and codification of sources is not merely academic. It is essential for interpreting and applying law in real disputes. In conclusion, the history of codification of the sources of international law demonstrates a continuous evolution. From medieval treaties and scholarly reflections, through Grotius, Pufendorf, Vattel, and Wheaton, to the Hague Conventions, soft law instruments, the League of Nations, and finally the ICJ Statute, we can trace a continuous effort to identify, organize, and formalize the principles governing nations. Understanding this history equips anyone studying or practicing international law with the perspective needed to interpret, apply, and advance the law today. In our subsequent lectures, we will examine each source individually, exploring its characteristics, significance, and practical application. So until the next video, take care of yourselves, and I'm looking forward to seeing you again.